Good afternoon, everyone. I'm Edward Liu from Hill Dickinson, Hong Kong. It is really my great pleasure to be invited again by Hong Kong Energy, Mining and Commodities Association and Economic Development Research Center to give today's presentation following my presentation given last Monday, I think. At that time, I was my presentation was on the impact of COVID-19 and its implication on crew change and global supply chain. And I gave that presentation as one of my role as the principal representative of International Chamber of Shipping China Liaison Office in Hong Kong. And like last time I mentioned that actually my full-time is a practicing lawyer for this resolution. So this time I'm giving this presentation with my role as a lawyer, as a legal director of Hill Dickinson. Today's presentation's title is Why Hong Kong Should Be Chosen as a Venue for Commercial Dispute Resolution in the Projects under the Great Bay Area and the Belt and Road Initiative. Very briefly about my firm, Hill Dickinson. We are an international firm of market-leading legal experts specializing in all aspects of commercial law, and also especially for shipping, trade, and energy disputes resolution. And we established our Hong Kong office in 2013. And in Hong Kong, that we specialize in most of the areas of commercial practice, including dispute resolution for general commercial, like self-goods contracts, shipping contracts, and also like company shareholder disputes and insolvency. And we also have two partners who are specialized in listed company, IPO and M&A. And again, very briefly about myself, I'm qualified in both England and Wales and China, mainland China. And my main practice area is commercial and shipping litigation and arbitration with a significant experience in international commercial disputes, especially in connection with the Belt and Road projects. And my main practice covers international arbitration, mediation, and litigation. And also I've quite a few Hong Kong government appointments, such as the promotion of arbitration committee and the steering committee on mediation, which are two of the government advisory bodies for arbitration and mediation. So for today's sharing, I'd like to start off by giving some background on the Belt and Road Initiative and Hong Kong's role in this initiative, and also the Great Bay Area Development Plan. As we all know that the Outline Plan was announced by the central government in February last year, and the objective and principles of the plan for this Great Bay Area is to establish Hong Kong as the center, of course, I mean as regards the legal service, to establish Hong Kong as the center for international legal and dispute resolution services in the Asia-Pacific region, and also to provide international legal and the dispute resolution services to the Belt and Road Initiative. It is therefore, from my opinion, very important for the Hong Kong legal community to carefully examine and understand the content of the outline to utilize the preferential policies under the central government's overall jurisdiction and make full use of Hong Kong's high degree of autonomy and attract more mainland and overseas enterprises to use Hong Kong as legal and dispute resolution services for disputes arising from commercial transaction related to this initiative. Today's presentation, I will hopefully, within this 30 minutes, to cover 6 issues. The first, as shown in the PowerPoint, is the risks and opportunities faced by Hong Kong arbitration industry. And the second is establish diversified dispute resolution mechanism. Third is to assist mainland China to promote a business environment of legal certainty. And fourth is Hong Kong as an international arbitration venue benefits from and provides assistance to the Belt and Road Initiative. And fifth, I will talk or elaborate the arrangement signed between mainland China and Hong Kong for the interim measures in aid of Hong Kong arbitration proceedings. And last but not least, I will talk about Hong Kong's legal services to help the country in global governance. So let's move on to the first issue, the risks and opportunities faced by Hong Kong arbitration industry. There is a very well-regarded international arbitration survey conducted by Queen Mary University of London. And the most recent two surveys were conducted in, or at least released in 2015 and 2018. As we can see from this slide, Hong Kong was the third most popular seat of international arbitration worldwide, and Hong Kong IAC, the International Arbitration Center, was the third most preferred arbitration institution worldwide, and also for the regions outside Europe. And of course, everyone knows that the biggest competitors in this Asia-Pacific region are Singapore and Hong Kong, and indeed, especially for the legal services. And we can see from the 2018 survey, the result was honestly speaking a bit unsatisfactory, that Hong Kong dropped from the third to the fourth place in the most preferred seats, and also the HKIC has been replaced by the Singapore International Arbitration Center. So let's look at a bit details about these statistics. We can see here that for the percentage, you can see from this chart that 39% of respondents selecting Singapore as the most preferred seats, and which is 11% higher than the 20% of Hong Kong. And we can see from the chart that London, Paris, Singapore, Hong Kong are the top four arbitration venues recognized in this survey. And from this chart, we can see again that Singapore IAC got 36% of the votes, and this is much higher than the 27% for the HKIC. And of course, you see that ICC has the dominant position in the vote, and followed by London Court of International Arbitration, and Singapore IAC and Hong Kong IAC are the third and fourth ranked in the preferred institutions in the world. So what is the problem? It's important that we look into the problems. And according to the statistics, the four most important factors which determine the preferred seats are as follows. First is the general reputation and recognition of the seats. 14% of the respondents think that is the most important factor. And the second, for 30%, people think the neutrality and impartiality of the legal system is very important. And third one is the national arbitration law. And the fourth one is the track record in enforcing arbitration agreements and arbitral awards. I don't know exactly the scores of Hong Kong and Singapore in those four areas because the survey report does not review that. But according to my experience in arbitration, international arbitration over the years, their scores in, for example, the national arbitration law and the track record in enforcing arbitration agreement and arbitral awards, there should be no significant difference between Singapore and Hong Kong because, for example, the national arbitration law, both Singapore and Hong Kong adopts the UNCITRAL module law for arbitration. And also, both Singapore and Hong Kong are very well known for their judiciary to support arbitration. The chance of challenging arbitral award is very, very slim. And I think that in last year, or at least in the past few years, there are only probably zero or one or two single cases has successfully challenged arbitral award. So for the third and fourth, I don't think there are too much difference. And the second one, I gave two numbers you can see from the World Justice Project Rule of Law Index 2020, which is also a very well recognized index in the world to assess the 128 jurisdictions that whether which jurisdiction has a more better rule of law index. And we can see that Hong Kong ranked the 16th out of this more than 100 jurisdictions in the rule of law index and 11th in civil justice factor. And Singapore, on the other hand, ranked 12th and 6th respectively in both rankings. Of course, if you see the rankings, it seems like that there's some difference between these two jurisdictions. But when you look closely to the scores of these two factors, you will see that the scores between these two jurisdictions are very, very limited. So again, a fair assumption would be made is that for the neutrality and impartiality of the legal system, I don't think there are too much difference. So based on my experience, it seems that the most difference between in the rankings of Hong Kong and Singapore may be more subject to the first factor, namely the general reputation and the recognition, which is actually more subjective and depends mainly on the strength of the two places in shaping the arbitration brand names and the influence exerted on the other regions. Taking shipping and arbitration industry as an example, Singapore has achieved remarkable results in shipping and trade arbitration through more than, I think, 15 or 20 years of hard work and has gradually gained wide international recognition. For instance, there's a very famous newsletter named the Lloyd's Maritime Law Newsletter with a history of nearly, I think, about 40 years, has been working with the Singapore Maritime Arbitration Association since July 2018 through publishing the maritime arbitral awards administered and recommended by Singapore Court of Maritime, Singapore Commission of Maritime Arbitration, the SCMA. The awards published in RMN are more likely to be cited by relevant authorities and even in court judgments, which of course undoubtedly enhances Singapore's presence and recognition in the global maritime law sector. And also with the increase in arbitration dealings, many top UK law firms or barristers have been attracted to set up offices in Singapore. So that is indeed, a very achievement, the difference between Singapore and Hong Kong, at least from the maritime and trade practice. And also I can give you another example that the selection of Singapore as an alternative arbitral seat for standard format contracts can also greatly increase its presence in the international shipping and trading market. For example, that they gained the BIMCO, one of the biggest shipping organizations in the world, to make Singapore as a recognized venue for shipping arbitration in their standard contracts. And Singapore has also led to make a few international contracts for maritime industry to be used. And of course that since those are Singapore version and there's no reason for the not true Singapore law and Singapore arbitration in those contracts. So we then now move to the second issue, that to establish the diversified dispute resolution mechanism, that when we are facing those difficulties, and what kind of opportunities that we can gain from the Great Bay Area and the Belt and Road Initiative. And there are three most important elements that I think need to be discussed, is branding, globalization, and specialization. We have to look at, again, the outline plan, which elaborate on how to promote the establishment of a diversified dispute resolution mechanism. Is mainly through four sectors. First is the improvement of international commercial dispute resolution mechanism. Second, the development of an international arbitration center. And three, further the exchange and cooperation between the arbitration and mediation organizations in Guangdong, Hong Kong, and Macau, the three places within this Great Bay Area. And last but not least, to provide arbitration and mediation services for economic and trade activities in these three places. So by doing so, we can achieve the golden principles of the Belt and Road Initiative, which are consultation, contribution, and shared benefits. So let's look at how could we establish the diversified dispute resolution mechanism, which is the priority as stated in the outline plan. I think is that we need to gradually explore arbitration business in the Great Bay Area, and then also attract Hong Kong mediation as agencies to set up branches in Shenzhen and Guangzhou. In this regard, I would like to elaborate a bit detail, is that mediation, of course, for the mainland Chinese legal professionals, they will think that actually mediation is a quite well-known concept in China, in mainland China. But the mediation in China, the traditional mediation in China, is, I would just not say entirely different, but at least to a large extent, that there are quite different concepts. So the mediation for the international commercial disputes is to engage a mediator, and then who will not be the adjudicator or arbitrator or judge of any issues between the parties, but only try to facilitate the negotiation between the parties and try to convey their interests, concerns, and demands between those parties. And finally, try to help the parties to find the common grounds and then resolve the disputes amicably. So that is the mediation in Hong Kong and the rest of the international commercial world. And therefore, it's necessary, and Hong Kong has the advantage of having quite a few very established mediation organizations, so that we should encourage those mediation agencies to set up branches in Shenzhen and Guangzhou, so that we can collaborate with those cities to enhance the awareness of mediation. And finally, and also to establish the mutual recognition of qualifications for mediators, and then to formulate mediation rules. And the third issue that I'd like to very briefly mention is how could Hong Kong assist mainland China to promote a business environment of legal certainty. A good business environment is an important idea of China's reform and opening up policy. At the National Two Sessions, 全国两会, held in March 2019 last year, the State Council's annual government work report listed the optimizing business environment to stipulate market vitality and social creativity as the major task of the central people's government. Therefore, while the country aims at providing a worldwide business environment, Hong Kong can definitely leverage our own advantages of a highly globalized and regulated business environment and apply the relevant advanced concepts and tailor her best practice to the Great Bay Area. In order to create a legalized business environment in the Great Bay Area, the outline plan actually proposed to strengthen the judicial exchange and the cooperation between the three places, so that quality, efficiency, and convenient judicial services will be provided for the construction of the Great Bay Area. And of course, because of the different legal systems in these three places, inter-regional judicial conflicts are unlikely evitable. Therefore, it is necessary to establish a source-sharing mechanism between the judiciaries on foreign-related laws and regulations, case acceptance, judge documentation exchange, and specific case analysis. On the other hand, it is also important for lawyers, arbitrators, and mediators to go hand in hand to explore establishing the professional contracts and cross-border cooperation mechanisms in the three places. So the next one that I will explain how Hong Kong as an international arbitration venue can benefit from and provide assistance to the Belt and Road Initiative, especially, as I mentioned, the arrangement signed between these two jurisdictions, i.e. mainland China and Hong Kong, for the interim measure in aid of the arbitration proceedings in these two jurisdictions. As an important supporting area for the Belt and Road Initiative, the outline plan for Great Bay Area proposed to promote the handling of dispute resolution disputes through alternative methods, including arbitration, mediation, and consultation. And again, as the 2018 International Arbitration Survey demonstrates, 97% of the respondents indicated that their most preferred method of dispute resolution was international arbitration, and therefore international arbitration definitely has a very large potential market in the future, and now, of course. So in light of the continuous development of trade or globalization and the Belt and Road Initiative, it is reasonably foreseeable that the number of disputes related to cross-border investment and international trade will surge accordingly. And as we all know that Hong Kong has a reputation for a strong legal system based upon the rule of law and judicial independence, under the framework of one country, two systems, Hong Kong is the only common law jurisdiction within China which the common law system is familiar to the international commercial practice. And also Hong Kong enjoys the protection of the basic law and the integration of Eastern and Western cultures. And this is a distinctive geographical advantage and wide use of both English and Chinese, which are both official languages of Hong Kong. And there's no doubt that Hong Kong is an ideal place for international arbitration, especially that if the cases are related to China. So what is the relationship between the arbitration and the Belt and Road Initiative? It is believed that with the advancement of the Belt and Road Initiative, more foreign-funded enterprises and wholly foreign-owned enterprises will be established in the mainland, and also those free trade zones established in the past few years in various cities and provinces in China. And however, under the current Chinese law, If two companies agree to conduct arbitration overseas, including Hong Kong, the relevant arbitral award may not be recognized and enforced in the Chinese courts. In light of the above, the Supreme People's Court had issued documents to provide judicial assistance and protection for the Belt and Road Initiative projects. And particularly for Hong Kong, as I mentioned, on 2nd April last year, the Supreme People's Court and the Department of Justice of Hong Kong signed a document, the name of which is Arrangement Concerning Mutual Assistance in Court-Ordered Interim Measures in aid of arbitration proceedings by the courts of the mainland and of the HKSAR. And that this arrangement took into force on the 1st October 2019. And I will mention, I will elaborate more, but I'm very happy to mention that I was the first lawyer, and of course my firm was the first firm in Hong Kong to assist our clients to obtain the interim measure order from a Chinese court immediately after this arrangement came into effect. And of course, the figures, so far as I understand, is no longer updated. But you can see that even until February this month, only 4 months or 5 months after the arrangement came into effect, the HKAC has already processed 13 applications made to 10 different mainland Chinese courts, seeking to preserve evidence and assets worth about RMB 5.5 billion in mainland China. And also because of this arrangement, Hong Kong is the first and only jurisdiction outside mainland China where the mainland Chinese courts can grant interim measures in aid of the arbitration proceedings. I will not mention too much about the background of the arrangement, but the arrangement but I would like to say more about the arrangement itself. That under the arrangement, the parties to the Hong Kong arbitration can apply directly to mainland intermediate People's Court for 3 preservation orders: property, evidence, and conduct, which as for most of the legal persons and also for those enterprises who has been involved in litigation or arbitration know that these 3 preservation orders are very important to sometimes even to assess whether you need it's sensible for you to initiate a litigation or arbitration before. So in short, the arbitrations, in short, under the arrangement, parties to the arbitration proceedings seated in Hong Kong and administered by one of the eligible arbitration institutions can apply for the interim measures, as I just mentioned. And also, this includes before the arbitration institution has accepted the arbitration case, provided that a letter from the institution certifying its acceptance is submitted to the PRC courts within 30 days after the interim measure is adopted, failing which the PRC courts will discharge the interim measure. This is because of the Chinese civil procedure laws requirement that for a pre-arbitration interim measure application, the party applied for the measures must commence the relevant arbitration within 30 days. And however, of course, there's some disadvantages of the arrangement. For example, it does not cover ad hoc arbitration, which is more commonly used in maritime and trade arbitrations. And therefore, also to enjoy the benefit from the arrangement, the parties should opt for arbitration administered by recognized institutions in their future arbitration agreement. The 6 qualified arbitral institutions are these 6 institutions, for example, like HKIC, and also the CTAC, and also like Hong Kong Maritime Arbitration Group. And the procedures. After a party has successfully obtained, when applying to the Hong Kong courts, the party shall submit application, supporting affidavit and exhibits, skeleton argument, and the draft order to the High Court of Hong Kong. If you make the application to Hong Kong courts. But on the other hand, that if you apply to the mainland Chinese courts, you need to make the application to the Intermediate People's Court of the place of the residence of the party against whom the application is made, or the place where the property or evidence is situated, but not both. And also the application made before the mainland courts will be governed by Chinese law and shall be made in accordance with the civil procedure law of the PRC, or the arbitration law of the PRC and the relevant judicial interpretation. Therefore, it's very important for the Hong Kong party to engage a competent local PRC lawyer to assist in making this application. And also, I want to mention very briefly about the cost of arbitration and interim measure applications under the arrangement. Article 10 of the arrangement mentions that a party who makes an application for interim measure shall pay the fees in accordance with the laws and the regulation on litigation fees of the requested place. And generally, 2 types of costs may arise in an arbitration. The cost of the arbitration, which include the tribunal's fees and expenses. Second, the administrative fees and expenses of the institution. And thirdly, the reasonable cost of expert evidence, advice and other assistance required by the tribunal. But the cost of the reference means the parties' cost of preparing and submitting their cases to arbitration. And this also includes the cost of interlocutory application where the arbitral tribunal has made no separate order as to cost of such application. But the disadvantage of arrangement which I found after I successfully managed to obtain the interim measure order is that we cannot, on one side, apply to the Chinese court for the legal fees incurred by our clients in making the application. But on the other hand, when we make the application to the Hong Kong tribunal, the tribunal says that it is out of their jurisdiction to make the relevant cost order. And therefore they said, why not you make the application to the mainland Chinese court for the cost order? So that for that particular cost, our clients were not able to recover, despite that they will succeed in their arbitration. So that is the problem that I think in the future, when we review the arrangement, we need to get the improvement on this arrangement, on the relevant provisions. I will not further discuss this because it's to be more practical and more academic, and also because of the time limit. So I will move on to the last part of my presentation today, is the Hong Kong legal services can help the country in global governance. The outline plan for the Great Bay Area specifically mentions the need to strengthen cooperation in Shenzhen and Hong Kong legal affairs to create an international legal service and commercial dispute resolution center. Aside from enhancing its development, Hong Kong, I think, should also shoulder the responsibility of promoting the establishment of a high quality and international diversified dispute resolution mechanism within mainland China, especially in the Great Bay Area. And therefore, the legal professionals of the Great Bay Area can collaborate to provide legal support to mainland China and overseas enterprises for going global and coming in under the Belt and Road Initiative. In this regard, the Hong Kong industry should make use of its advantage in its understanding and familiarity with the application of common law-based international business practices to assist the country in promoting a set of rules and regulations in line with international standards with more open vision and wider perspective. And in conclusion, with a well-established international arbitration system, I believe that Hong Kong is well suited to be a venue for commercial dispute resolution in the projects under the Belt and Road Initiative. And that concludes my today's presentation, and thank you for your listening. And if you have any questions or inquiries, please feel free to reach me through the association organizing today's presentation. Thank you very much indeed.